going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Friday. We made it to Friday. I'm going to try being on camera tonight. I just want to see. How it works. So, yeah, you're going to get to see me a little bit tonight. I don't know if that's a good thing or a bad thing. You guys can decide that on your own. But I'm going to be on camera for as long as I can. Yeah, that's all I got. We're going to watch some court. You guys want to watch some court? I don't know. Now I'm watching myself on camera. I don't like this. I'm in my living room. I'm not sitting in front of my green screen. You're just going to deal with that as well. I don't care. So we're just going to watch some court. I've got a lot of Judge Clark videos tonight. We're going to start with Judge Slaven. Judge Slaven had a good one today, and then we're going to finish the rest of the night with Judge Clark. So hopefully you guys like them, because that's where we're going. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right. From Scareforce Falconry, sir, what is your last name? Just so I don't want to say the individual from Scareforce.
Sure. My name is Paul Thomas, sir.
Tom's?
Paul Thomas. Thomas.
All right. All right, Mr. Thomas, you had the opportunity to speak with Ms. Francis. Let me get Ms. Francis back to the main session.
I actually kind of lost the connection for a minute, so I returned back to here. I don't know if we resolved everything. She said she would be back, but I took her a few minutes, so I didn't want to like miss anything here. So
sure.
I'm not sure what
check.
we're at with her.
If I have to, I can put you guys back into the breakout.
Okay.
So, Ms. Francis.
Judge, I was on the phone with my client.
Ms. Francis, you had the opportunity to speak with Mr. Thomas, and this is the original case on this matter was case 1502-2704 GC, Credit Acceptance Corporation versus James Harold II, garnishee defendants of Two-Way Transportation LLC. And that one's closed. And then also Scareforce Falconry and Bird Abatement. And I have.
Can we appreciate the name? Scareforce Falconry. I just love that name for a business. That's all I had to say. Let's go.
Mr. Thomas here. So, was there any resolution, Ms. Francis?
Jack Francis on behalf of Plaintiff's Attorney of Record. No, there was no resolution, Judge.
All right. So, Mr. Thomas.
Yes, sir.
Today is a motion for hearing for entry of default against the, against Mr. James as to the fact that he is employed with Scareforce Falconry and Bird Abatement. Is that correct? Is that a correct statement? Does he work for you?
Yes, sir. He works for me.
All righty. And you received the garnishment?
I did get a garnishee disclosure. Is that the form you're just indicating?
Yep.
Okay. Yes, sir. I did get that.
And did you abide by it?
I delivered the garnishee to Mr. James. I'm just a third party here. I'm not anybody's side. I feel like if you borrow money, you should pay it back. But he's indicated to me that he's already paying like $150 a month for child support that he can't afford the garnishment, and that if I garnish his wages, he'll just go find a new job. So I'm in a position where I feel like I'm going to lose an employee the moment that I garnish his wages. Again, I'll abide by whatever the court tells me to do. This is the first time I've ever encountered this. So when I got the writ or the garnishee disclosure, I did deliver that to him. I I was trying to figure out what I need to do with it, but then I got the notice to appear. And so I just figured the best place to address this would be with you in the court. I'll comply by whatever the court tells me, but the counsel here is telling me I have to pay him $500 when I send in this garnishee. I don't want to be extorted for money that I don't feel like I owe. I didn't enter into any agreement with anybody. I'm just an employee with a guy that needs a job, you know? And so she's trying to tell me I owe her $500 when I send in this garnishment, and I don't see how that's possible. So I'll abide by anything the court tells me to do. But, you know, the attorney here is trying to tell her I need to send her $500. I'm not going to be extorted, I guess. So I referred her back. I said, I'd rather talk to the judge and get my orders from you, since she's not a judge. She's just an attorney for the plaintiff.
Sure. All right. So you do realize that your best bet is always to, when you get any kind of legal documentation, and I'm not giving you any legal advice, This is common sense. You might want to call and show the paperwork to an attorney and go, hey, what's all this about? Instead of saying, I'll just wait. Because technically, listen, if somebody works for you and somebody files a garnishment, you need to abide by the garnishment disclosure and all those things you need to do under the law. Because if you don't, you could be on the hook for the same for the money. Okay, sure. That's what they're seeking, is basically, well, then I guess we'll just get the whole judgment. We'll get all the money from you then. So listen,
which I never signed anything. I know that's how the law works, but it's
listen, talking over top is not going to help you at all. I'm just going to.
Oh, sorry.
So, and I'm not ordering that today. I'm not going to enter a default against you. What I am going to say is this: if there's funds that you have of his that they can garnish, that Credit Acceptance Corporation can garnish. I don't know if you have an HR department or if you just do all the paperwork yourself for payroll.
I'm a small business.
Sure, no, absolutely, I get it. So, and I don't know if they're already garnishing child support, which is a priority one garnishment, which will take precedent over things like this garnishment. I'm not going to give you any legal advice. All I'm saying is you might want to seek an accountant and or an attorney who does these kind of things so that they can correctly tell you, listen, this is how much you can send them, or maybe they're already taking, like, there's only a certain amount of money, a certain percentage of someone's paycheck that can be garnished.
Right.
And it starts off with priority garnishments and things like, and then it just.
Yes, this is the boss. He's not. He kind of refused to garnish his employees' wages because the employee threatened to quit if he did it. So he came to court to try to fight for him. That's what's going on here. But shout out to the name, Scare Forest Falconry. I love that name. That's a great name.
There's a pecking order. Get in line. I don't know. I don't know what your numbers are. I don't know what he makes. So I'm not speaking to any of that. Ms. Francis, are you aware? So first off, Mr. Thomas, sorry. Mr. Yes, Thomas, do you take out a garnishment for child support already?
Yes, sir, I do.
Okay, and that comes from the front of the court?
Yes.
And you're abiding by the front of the court's order, so you take what the front of the court tells you?
Yes, sir.
Okay. So, Ms. Francis, with regard to the garnishment for the wages, what is it that you, I guess, I don't know if there's what's available left over is what I'm saying. So,
well, Judge, we don't either. He didn't fill out the disclosure. If he had, then we would know.
I'm going to have Mr. Thomas, I'm going to adjourn this matter. And I'm going to adjourn this matter to, let's see, well, we're not here on the 4th of July, July 11th. Okay. If you don't have that disclosure and all that information to Ms. Francis's office by the 30th.
Yes, sir.
All right. Then you are gonna pay her attorney's fees for having to come here today, because if you just sent that information in and then they know, they're like, oh, wait a minute, he's already being garnished as much as he can be garnished. We have to seek some other remedy, I guess. See, that's the whole part of the disclosure, is that you got to follow that so that they know, because they don't know how to exercise their rights if somebody who legally has money that is owed to the defendant, if they have to pay it, some of it to them, or so that's why you got to follow those things. So
I understand, sir, and I apologize that I didn't send it in. Once I I'd gotten, I was trying to figure out how to proceed with it. And then I got the notice to appear. And so I just felt like the best thing would just be come here, get directions.
No,
from the
and
court,
that's
I will
why what I'm saying
buy
is
everything.
have all of that sent in by the 30th so that they can proceed accordingly, okay?
I'll send it in today.
'Cause I don't know how much he makes, they don't know how much he makes, what the child support garnishment is, what percentage of his entire amount of money he made. So,
Right.
and I have no way of knowing today so that I can say X, Y, and Z, but I'm also not gonna take some small, because I think I wish the law would be changed a little bit on this whole, you can just, hey, you know what, if the garnishee defendant doesn't send in the paperwork or doesn't, you know what, we'll just get our whole judgment against for that guy. Like, yeah, I don't think, really, I'm trying to do a small business and I hire a guy and all of a sudden now I gotta pay his debts. Yeah, that's not happening. I think that's just.
Yeah, I appreciate that.
I don't even see how that's even, it's garbage. I'm sorry, I just don't like it. But I gotta
I didn't
follow
sign
the law.
anything. I didn't
gotta
enter into
follow the
any
law.
contract, so.
No, I gotta follow the law. I get that, but.
I do, I
same-
understand.
So I'm not trying to
Well-
put this whole judgment on you, so,
I appreciate
Well,
but.
Judge,
Because you hire
Judge, at the same
Yeah.
time, he's saying this is the first time he's gotten a garnishment, didn't know what to do, but he just said that he is garnishing the employee's check already. So, and the garnishment was issued back in January. We sent him the notice in April. He got the failure to disclose in May, and then he got the notice to appear. So him saying that he waited just because he got the notice to appear, that was months later. All this time, we could have been getting funds from his check, and we have not. And so that's why I asked him to send the disclosure over today. We have an email on the letter that we sent him, and and then I said that we are entitled to costs. All this time we could have been getting funds, or we also did all this work just to get him here to talk to us. He didn't call us. He didn't do anything,
here.
Judge.
I'm
So
here right
that's
now.
why.
On my court date.
Stop interfering. No, it is your court date. He just said it's not my court date. No, you got the notice. The attorney's absolutely right. You know how to do this, but her argument does make sense. But he did say, "I'm going to lose this employee if I do this." So her argument makes sense. His argument makes sense. This is why I'm not a judge. What would you do in this situation? I'm going to adjourn it. You guys work on it. That's what he does. I don't know what else to do here.
Yeah, I'm not gonna, I mean, he's running a small business. He's not the one who entered into a thing with Credit Acceptance Corporation. So he didn't, he got the garnishment from front of the court is a lot easier to follow, like what they want you to do. And so, you have that, listen, so you know what, I am gonna move that.
Miss Orchid Blooms, please tell me you saw that case today in Dane County. I cannot wait to release that over the weekend. $10 million bond. Oh my gosh. For those of you that don't know, the video I released, I don't know, yesterday or the day before, with the couple that tried to poison the exes with cyanide. He was in court today, and it was huge. That's going to be released over the weekend, though. But Miss Orchid Blooms knows what I'm talking about. I just really hope she saw it. $10 million bond.
The time frame up, because Miss Francis told you that there's ways you can just email her the information. So have that to her by Tuesday, 24th. If you can't email
Yes, sir, I'll
that.
get it out right away.
If you don't, I'm just saying, if you don't, Miss Francis is going to file an affidavit of non-compliance, telling the court that you did not have that into the 24th. And then I'm gonna award $500 in attorney's fees for the fact that you now, after I've told you, after you are crystal clear as to what to do, you're not moving with the speed you need to move. So 24th.
Yes, sir, I'll get it right away.
All right. So, and then we're gonna, if you guys work out everything and everything gets squared away, then obviously, Ms. Francis, there's no need to come back on the 11th. But if we don't, and if things aren't, I gotta make a ruling on something, then we'll do that. And then we'll do that on the 11th, okay?
Judge, can I ask just one question real quick? I will get this in today.
I may I may or may not be able to give you the answer because if it's legal advice, when I'm wearing a robe, it's like being a referee. I can blow a whistle, call a foul, throw a flag. I can't coach either team. So,
Nope, it's
but
nothing like
go ahead.
that. I just wanted to get some clarification on the time. You said July. I'll have this in, so it shouldn't be an issue. I don't need to show up as long as I get this in. Is that correct? But July at what time? I just want to make sure I don't miss any court dates.
8:45.
Okay. All right, I will have it in today. I'll get it in right this afternoon, and hopefully that'll resolve the matter.
All right. And both of you have a good weekend. Now, Ms.
Thank you,
Francis, let me put you in with breakout room 3 with Ms. Reynolds.
All right. That was just a, a little appetizer to start our night. Judge Slaven, always a good option. Always a good option for court watching. And I really like the name, Scare Force Falconry. And I'm not gonna lie to you, I had to look up what a falconry was. I had no idea what they did. And I looked it up, and it took me, 5 minutes on the website to find what they do. They essentially they take birds out of areas, but that's not what the website says. It takes you a while to find it. Anyways, that was how we started it. Now, the rest of the video is Judge Clark. He had the docket of the century. Generally, when you watch an entire docket, you'll get one good case, 2 if you're lucky. He had banger after banger after banger after banger. So we're going to go watch Judge Clark. Let's go.
Okay.
We'll be here.
All right. Mr. Graham? Mr. Myers?
Mr.
No, I'm a deposit. I rewound it. All right, hold on. I just wanted to say thank you. 21,000. 21,000, that is awesome. I did hit 21,000 yesterday. Thank you guys for that. That's what I was going to say, but I rewound it. So now my brain's fried. So we're just going to keep playing. But a girl named Joe, thank you. Thank you for the congratulations. 21,000, that is awesome. 22,000 right around the corner. Let's go.
Okay.
We'll be here.
All right. Mr. Graham? Mr. Myers? Good morning. Mr. Myers, you're representing yourself, and I've made the determination you're competent to do that. Do you still wish to do that?
Yes, sir.
Okay. And what are we set for today?
I think his motion to continue, Judge, as I understand it,
All right.
trial, which is set for July 7th.
Yes.
State's position?
Is that right?
State's position?
We'd object, Judge. We've got subpoenas out. We're ready to go to trial.
All right. What's the basis for the motion?
Well, Your Honor, to prepare a better defense, these are complex crimes. The state also just sent a state second supplemental discovery, and they added a Category A witness, the medical examiner, and I believe I need to depose the witness before trial.
We designated the medical examiner as an expert. There's been an issue, I think if you're familiar in the trial, some of the defense raising the issue about, so we've just started redesignating all the FDLA and the medical side. He's been disclosed all along, Judge.
And they just added on May 30th, or they filed the second supplemental discovery May 30th, 2025.
Again, Judge, I believe all that did was just designate him as an expert.
Yeah.
They've had the autopsy report. In fact, I think it was an offer that he declined to see the autopsy photographs at the last court hearing.
Okay.
And he performed the autopsies on both victims also. And also, I have a writ of prohibition with the First District Court of Appeals.
I had something this morning, you have to file a fee. They've
Yes, sir.
waived your, they have denied your request to waive the filing fee.
They denied the second filing fee waiver.
I just got one, let me see, I got it in my email
The
this
second
morning.
one should have went in 2 days ago. Or?
I don't know, I just got one this morning, let me check. Court service order. The court denies a motion to pay violent fee docketed June 18th. So that would have been docketed.
Well, either way, I'll have it paid.
Okay, all right, well, Right now, it's not paid, so I'm prepared to try the case on July 7th. I'm gonna deny the motion to continue.
Could I go ahead and
Understand that
file a motion to depose the medical examiner? I have him with me.
How long the medical examiner's been disposed? I mean, how long? How long?
He hasn't been deposed.
Judge, he's been,
Here's
I
the
would say-
state's copy, and
From the-
here's a copy
from the
for
initial,
court.
we've just redesignated him as an expert judge in light of some of these recent objections, some of the.
Ms. Piazza deposed the toxologist, which is Dr. Coyne, not Dr. Radcliffe. Dr. Radcliffe actually performed the autopsies on both victims, Your Honor.
I'm sure he did. He's the medical examiner. He's been the medical examiner.
Your Honor, Dr. Radke was listed in the original discovery response file January 6, 2023.
That's what I'm looking at. So I'm gonna deny the motion. You've got to July 7th. If you want to try to depose him by then. But you still have a right to be represented by an attorney. And if I didn't, the public defenders should be backup counsel. If they're not, they will be backup counsel. I think Mr.
And Your Honor, honestly, they just sent me the discovery 5/5/25. I mean, I was represented by Ms. Piazza, but I am pro se, and these are complex crimes. With all due respect, I should be able to have more time to prepare a defense. These also have very limited case law in Florida. There's only been a very few convictions the whole time that the statute's been enacted. And I really believe the state's really just trying to push me into trial because I'm pro se at the moment. So I'm exercising my right to have the double jeopardy issue. Because Ms. Piazza refused to see the double jeopardy issue, I filed a motion, a Nelson hearing, to get new counsel. I'm pretty sure I proved that she was ineffective by filing that motion. You granted part of it. You know, you dismissed 2 of the charges that she refused to file a motion on. So therefore, she was incompetent.
I've denied that motion, sir. Was anything else we need to put on the record prior to July 7th?
I'd like to have these on the record.
You want to file them?
Yes, I would like to file a motion to oppose. Great copy. Here's a copy for court.
Judge, I would just like to, as far as a plea offer, it will be available through next Friday. The state would be willing to, right now he's looking at 2 life sentences. The state would, we talked with Ms. Piazza before she got off the case, we would consider 30 years to 2 counts of manslaughter, and that will be available through next Friday.
I'm available most of next week also. And sir, at any point in time that you request counsel will be reappointed, public defender's office will be reappointed, and just let us know.
Yes, sir.
Okay? That'll conclude today's hearing.
Thank you, Judge.
All right, Mr. Scott?
Mr. Nolan?
Your Honor, Chris Scott here on behalf of Kylan Nolan, 24 CF 1043. And Your Honor, we're here on a Nelson motion that was filed by Mr. Nolan.
All right, Mr. Nolan, if you'll raise your right hand.
Always swear the testimony you're about to give is the truth, the whole truth, and the truth, so help you God.
Yes, ma'am.
All right, and sir, what request are you asking for today?
We had came to a conclusion already. Me and him made an agreement over a Zoom meeting prior last week. So we just coming here to ask for a bond hearing.
Okay, so you're withdrawing your motion for a
Nelson hearing.
Okay, all right, so it's been withdrawn.
Your Honor, as far as an update on the case, we have deposition scheduled October 15th. I did file a bond motion that I would request the hearing on that bond motion. And that's where we are.
All right. And I'm prepared to go forward on the bond hearing, Mr. Sullivan. I can call you first witness, Mr. Scott.
Okay, Your Honor, I'll call Mr. Nolan.
I believe he's already been sworn in. You may inquire.
All right, Mr. Nolan, can you state your name, please?
Carlin DeMond Nolan.
Where do you live?
With my baby mother.
Where is that? What's the address?
She was supposed to be currently here, but she's not here. But my previous address was 1305 Transmitter Road.
Okay, so here in Bay County?
Yes.
Do you have any family other than your girlfriend here in Bay County?
I have a son.
Okay. How old's your son?
8 months.
And does he live with your girlfriend?
Yes, sir.
All right. What about work? Prior to being incarcerated, were you working in Bay County?
No, sir, just cutting grass.
Okay, so you were working under the table?
Yes, sir.
Okay. Do you intend to, if the court grants a bond reduction that is sufficient for you to get out, are you going to be employed when you get out?
Yes, sir.
You're back cutting grass?
No, I'm trying to go get a trade.
Okay. And is there an amount that your family currently has, or you currently have, that you would be able to use to bond out?
Yes, sir. At the moment, 2,000 to 5,000.
Okay. And have you ever failed to appear before the court?
No, sir.
Okay, so no FTAs in the
No,
past?
sir.
Okay, and if the court reduces your bond to a point where you can bond out, are you telling the court here today that you will come back to court?
Yes, sir. Positively.
All right. Is there anything else you want the court to consider in this bond motion?
I am trying to help my baby mother with my son because she is having a hard time, and she's doing everything by herself at the moment, and it would be more beneficial for my family if I could be able to be out to help my son, to raise him instead of raising him behind a cell.
Your Honor, I don't have any further testimony. In the motion, the bond that's set is relatively high. The charges are serious charges. However, Mr. Nolan is requesting that the court reduce that bond so that he can not only prepare for and fight these charges from outside of court, but also, as he stated, to take care of his family.
All right. Mr. Sullivan?
It appears that Mr. Nolan was first arrested in case 24-1043 for discharging a firearm from a vehicle and shooting into a building and waived to adult court on March 26, 2024. He was out on bond in that case when he was rearrested on case 25-595 for robbery with a firearm and false imprisonment. Based off of that alone, I think Mr. Nolan should be, quite frankly, held without bond on that previous case. In the 2025 case, there was a grand theft auto count that was not filed on, and I believe that was a $50,000 bond given, so I think that should be ROR. I did not file on that count. But beyond that, the nature of both of these cases and all the offenses that Mr. Nolan's facing are extremely serious, and the bonds that were given at first appearances are appropriate.
Can Mr. Nolan briefly respond?
Sure. I'm basically, my bond is so excessive, I'm basically held without bond, and I previously wasn't out on bond. When I was arrested on March 6, 2025, they came to me with 2 warrants. I wasn't out on bond. The last time I ever been arrested was in 2022, and I was stated to a program. I was a kid, and then when I came out, I was off. I had direct discharge, and I came out. I didn't have no probation, anything. I have been in trouble in Louisiana, but it was a fine that I paid when I was out on bond, and I've paid the fine in Louisiana.
Your Honor, it does. Looking at it, the 24 case looks like it was waived to adult court and filed in 24, but it looks like he may not have been arrested on that until he was arrested on the 25 case. So
He was first appeared on those all.
Yeah, I missed it. Was it within the last minute? I actually got up to go to the bathroom. Hold on. Oh, you know what? I'm not going to make you guys wait for this. I got to find this.
Yeah, I think he's correct.
So what I'm going to do is I am going to, and so he will not be held without bond on those. Those bonds will remain the same. I'll remove the $50,000 for the grand theft of an auto. I will on the robbery with a firearm, I'm gonna leave it at $500,000. On the false imprisonment, I'm gonna lower it to $100,000. I'm removing the $50,000, and I'll leave the $25,000 on the firing a weapon from a discharge from a firearm and firing into a building. So that would be, pardon? $650. That's the best I can do today. And when do you have deposition set in October?
October 15th, Your Honor.
All right, so we'll set this for our October 23rd pretrial.
Thank you, Judge. And that concludes my business.
Have a good day.
Thank you, Your Honor.
Mr. Henson?
Yeah, fire into a building. Find out. Oh, the mother of my child needs help. Yeah, you fired into a building. This is where you're at. Sorry, man. Seriously, what? I've got no words. I don't know if it's because I'm on camera or not, but I can't even think of things to say.
Your Honor, this is Mr. Dougherty in case 250045, and we're here for a Nelson hearing.
Yeah, everything has to do with Nelson hearings, people filing motions against their attorneys. This was Judge Clark's entire docket today. This guy's a whiner. You're about to find out. This guy.
Mr. Dowd, if you'll raise your right hand to be sworn.
solemnly swear the testimony you're about to hear is the truth, the whole truth, and nothing but the truth, so help you God.
Yes. All right, sir, state your name.
Jerry Doherty.
Mr. Doherty, what are you asking for today?
Your Honor, I appear before the court to express my serious concerns regarding my current legal representation and the handling of my case. I have repeatedly asked the attorney to file a motion of dismissal based on evidence of two individuals involved providing false statements in their police reports. They both are fully aware that my son was 21 at the time. She adamantly said he was 16 over and over to the police to insist that I be arrested. Despite this request, she says she's speaking for you. I don't know if this was something you said or not, that you would refuse to dismiss it, is what I was told. That you would not dismiss it, that it would not change anything, that she lied on the police report. She even just recently, she just did the depositions. And it also turns out that she did lie again under depositions. Officer Sanders also has spoken to her assistant and knows that she has lied. She's also has a warrant out for her arrest for theft of my property. She stole all my items inside my home, sold them at pawn shops. They have her on video footage. And I've asked Miss Beasley to please explain. She cannot explain to me why this continues. She just shrugs her shoulders and says, okay, it is what it is. It just continues on. And I don't understand, and I can't get her to submit with me in writing why these charges are continuing, why her lying is being admitted and just shunned under the rug when they know this is true. And my son, he was coerced in the lying. On the police report that you have, if you look at his age, you can see it's like, it almost looks like it should be 2003. It looks like it was made into an 8. I've asked to look at the evidence as far as the video footage. And when I went to go review it, it starts off with the police officers behind my couch, lacking context of when they knocked on the door, they said I was under arrest. They come in, begin to question me without reading my Miranda rights.
I'm getting all that. What, Ms. Beasley, what's your response?
Your Honor, I have told him that it's not the matter for a motion to dismiss because he doesn't agree with what the evidence is, or that a witness, he feels that they've lied. That's not something that I can do on a motion to dismiss.
Hush.
He was.
You're not testifying right now.
Again, I've asked for context and I don't receive it when I ask.
I'm getting context right now. I'm the one that she's talking to right now.
He has asked for me to write to him to tell him about his case. It's not typically what I do, so I set up phone appointments for him. They always have the option to come into the office. We've had multiple phone appointments, Your Honor. When he was in jail, I met with him several times. I don't think I've ever shrugged my shoulders and told him it is what it is, but these cases do take a while to resolve. I've tried to explain to him that I can't make the state dismiss the case. I can't make the state give him any particular offer. I can't.
I've heard about that. It is what it is. If a witness is lying, your option is to go to trial. That's the option.
But she couldn't explain that, sir.
That's a jury question whether she's lying or not, or where he's lying or not.
The police know she lied. Everybody knows she
It
lied.
doesn't matter. That's not a basis for a motion to dismiss.
Why is
That's
one?
not a basis for me to appoint you another attorney. So I'm gonna deny your motion to discharge your attorney.
Sir, she contacted me at 7:30 in the morning. That's not appropriate either.
Who?
Miss Beasley. 7:30 a.m. is when she decides to
I
call
would
me.
love for if I had an attorney, if they got up then at 7:30 in the morning and contacted me. My gosh, she's at work and she contacted you. So I'm denying your motion to appoint counsel. You can represent yourself or you can go hire an attorney. You're out of custody. That's up to you, but you've got Miss Beasley. We need to set this for another court date.
Yes, Your Honor, the depositions are
I'm
done.
gonna find that Miss Beasley is competent in her representation. Just because you don't agree with her is not a reason.
She can't answer the questions for review of the
Listen, I'm
third
not arguing
party,
with you
sir.
anymore.
I'm asking my.
Listen, hush. I'm not arguing with you anymore.
I don't want to argue, sir. I just want to ask you one question.
I'm not answering any questions. That's it. We need to set it for trial.
He's set for pretrial July the 15th. I do need for him to listen to those deposition audios that we've got.
Okay.
So I don't know if he wants to come into the office and make an appointment with an investigator to do that. We did have some issues before.
We'll just leave it on that pretrial, July 15th at 1:30. We'll see you then, sir.
See.
Yes, ma'am.
Over here.
Mr. Ware.
All right. Yeah, the jail was making a lot of noise during that hearing. Jacqueline Powers, thank you so much for the 1 month. I appreciate it. That is awesome. 1 month. Praise to the mods. Absolutely. The mods run the channel. They do. They really do. I just show up with content and they run the channel. So thank you to the mods as well. All right. We're going to continue on with Judge Clark. This is the entire docket that happened today. People show up with motions. He's like, nope, not happening. Bye. That was the docket today. So I'm just gonna show you all of them. Or some of them.
The one I have before you this morning is a similar posture to
There are some that I didn't play. I played most of them.
the one Ms. Beasley just had at State of Florida versus Joshua Smith. Calm down, Mr. Smith. Your Honor, Mr. Smith has filed a number of pro se pleadings with the court. The problem is he's not representing himself, so the court hasn't been able to address those. He is requesting the court appoint him a fifth lawyer. As you recall, there was a public defender, the Regional Conflict Office. Jonathan Dingus unfortunately passed away. And now my office, as well as the private investigator, Dan Estes. So I will step aside and allow Mr. Smith to argue why a fifth lawyer should be assigned to the case.
Raise your right. Solemnly swear the testimony you're about to give the truth, the truth, so help you God.
Yes, ma'am.
5. He's on public defender number 5. Yep. Lucky number 5. This guy's going to be a gem, right?
Yeah, you may go forward.
Yes, sir. Thank you, Judge. First, I was like, start out. I believe the lack of attention to his or to this deficiency in the preparation for the depositions and applying the Florida statutes has greatly undermined the future outcome of my trial. The mere fact that my counsel has wrote a letter which should be attached to the evidence shows that my counsel hasn't applied the factual evidence from depositions to the body cam footage.
He is saying 10 words and flipping a page. I'm a little worried. Watch him. He says 10 words and flips a page.
As well as him advising me that if I paid an attorney, I could get a good representation and a suppression motion. Shows his lack of commitment to his client, to this particular case. The statement alone depletes the barrier of trust in my counsel. It appears that my counsel is biased towards either me or this particular case in general by the clear ignoring of the facts of evidence. Your Honor, I have asked my attorney multiple times. My wife has copies of emails where she's emailed him for evidence to obtain before depositions so we could do a proper deposition because to my understanding, there is no CAD calls. And I happen to know these officers were technically out of jurisdiction when they stopped my car. And I asked, can we please get a CAD call so we can contradict the jurisdictional violations and the other problems in the case? We haven't got that. We, to my knowledge, it still doesn't exist. There's other things I've asked. We filed a Brady demand back in, I think it was November, and we waited till after depositions to file a compel motion. So I feel like my due process rights have been violated, because how can you properly prepare for depositions if you don't have the evidence that you want to attack? For instance, we've got the body cams after, or we got the, we got the supposed video of the control buy that was supposedly in the affidavit stated was caught on recording selling a suspected 14 grams of methamphetamines. If you review the control buy footage, it doesn't show me, it doesn't show my vehicle, it doesn't show my voice or anything like that. These are things that could have been addressed in depositions and on a counter argument, especially the traffic stop, because the body cams say they stopped me for this incident, and then in depositions they change and say, oh, well, we stopped it for this, but there's no factual evidence saying this. And then you said you reviewed my car at the restaurant at 10 p.m., but you pulled me over at 11:32 p.m.
Mr. Saline, your response?
Sure, Your Honor.
And I reviewed the motion and the I think placed on, but if you want to go ahead and respond to.
Oh, sure, Your Honor. The discovery, as you may recall, we just had a motion to compel at our last time before you, and Mr. Sullivan stated to the court that we have everything in the case file. In fairness to Mr. Sullivan, sometimes even the state doesn't have everything provided to them by law enforcement. It regularly comes up during depositions. Oh, you didn't get a copy of that report, or, oh, I didn't enter that into whatever. So the discovery items, I think we already addressed at the last court date. The not filing a motion to suppress, that's easy, because no one in their right mind would file a motion to suppress when you haven't completed all your depositions. We still have a deposition of former investigator Raymond McNeil. He was scheduled April 22nd and served by the sheriff's office, but did not show up. He's been rescheduled to be deposed in August. There's no one going to trial before deposition occurs. There was a motion to continue the trial filed June the 4th. Trying to think what else was just put together as far as any type of jurisdictional issue. If he read the deposition transcripts, he already knows the answer to that situation. We've acquired everything that's been asked of us, including the file that Mr. Dingus had, which does not contain most of the items that Mr. Smith indicated Mr. Dingus possessed. So, I mean, I'm happy to answer anything else, but quite honestly, Judge, I think you have a couple things. One, Mr. Sullivan thanks you for giving your trial strategy to him by sharing the letter. But I think you have an individual who wants to represent himself, but wants another bite at the apple for appeal purposes by saying he had an attorney. That's evidenced by all the pleadings that have been filed. I also think that this is difficult when reality sets in. The plea offers the 25 years. Mr. Sullivan's let it be known that he will file pursuit of habitual felony offender and ask you to give basically a life sentence. And so lo and behold, as predicted, a Nelson motion comes forward. So I have no problem if he gets a fifth or sixth or seventh lawyer, as long as the record's clear that, much like the first three, we've done everything that's been asked by the court, including Dan Estes, who's not here, but our private investigator, my God, was there even yesterday morning, despite this motion pending.
Investigator has definitely did his job.
All right, I am going to find that Mr. Slaven has done what he's supposed to do, and he's provided competent representation. I'm going to deny your motion for conflict-free counsel. There is a motion to continue the August 4th trial. Does the state have any objection?
Was it just to do the deposition?
Deposition, and then he has a motion to suppress. He wants.
If I can get ready to come in before then, can we leave it for that August date?
Yeah, I mean, I'll file the motion to suppress, like Anders.
Judge, I'd like to leave it set for now for that August trial date, and
We'll leave it, and we'll set it for July 22nd at 9 o'clock for any motions and trial management.
Okay.
Yes, sir.
I'm fine with, I understand that. There's critical parts in it, like for instance, the CAD call. I would like a copy of the CAD report.
I can't, I'm not, that's not up for me. I've already made all the rulings I'm gonna rule, okay? And Mr. Saline's heard what you wanted, okay? All right, we'll see you then.
Thank you, Your Honor. That was all.
Like I said, motion after motion, denied. This was Judge Clark's docket. I don't have any words. We're just going to keep watching.
Yes, Your Honor. Before you is Marcus Mathis. He's in the.
I usually don't do this. I usually don't just take a docket and play a bunch of cases from it. I feel like that's a lazy way to go about it. You know, anyone can do that. You can just download the entire docket and just play and say, "Hey, let's go hang out." Judge Clark had a lot of pro ses today and a lot of motions. So, yeah, I took the lazy way today. It's not my normal way of doing it.
Gallery, Your Honor. I don't know that he needs. He can be up here or. This is case number 2771. In this case, Your Honor, we filed a motion to compel discovery. The motion outlines essentially everything we've done. I don't think there's an argument that we've complied with the discovery rules in requesting discovery. We've made several attempts to get a video of the transaction. Mr. Mathis is charged with a sale of a controlled substance. The transaction was captured on audio video, and the state is, I don't know about the state, but they're representing the police department, which they're refusing to give us the video, saying because it claiming some sort of exception that I can only take a guess at in the rules, that because the CI can be seen on the video, they are entitled to not disclose it. Is that pretty much it?
There's an audio video?
Yes.
Oh, I thought we still had one more case before this. This is a really good one. Oh, this is so good. Lawyers that are in the chat, pay attention to this because I want to ask questions. I don't want to spoil it. Oh man. Okay, I wasn't ready for this. I thought I had one more before this. This is the last clip of the night. So apparently it's a short stream tonight, but this is good. Let's go.
I'm at a loss too, Your Honor.
Of the offense?
Yes.
The alleged offense?
Yes, Your Honor.
They don't want to give it because of the CI?
Yes, Your Honor.
I'm prepared to grant the motion. I mean, I guess you could do some sort of a writ or something, but I understand protecting the CIs, but they've got an audio video. What's the state's argument?
I may pass forward, Your Honor. I'm passing forward State v. Carter. This is 29 Southern 3rd, 1217. Your Honor, this case references Riviro, which is kind of a seminal case on protecting CIs and when disclosure is required. Specifically, what this Carter case says is that just simply saying I would like the disclosure of the CI is insufficient. The defense has to provide or make a preliminary showing that a colorable defense is.
Well, I know that. I understand that. But I mean, you have a video and an audio of the actual offense that you're charged with, and they're not entitled to that because the CI can be identified?
Sure. Believe me, Your Honor, I mean, if the video shows him committing the offense, I absolutely would love to use it in trial. I mean, it's going to be more inculpatory than anything else. So I'm.
Have you had a chance to view it?
I've not. No, I've not been able to review it. They've not provided it. But I understand the rationale of checking the CI and the.
I understand that too, and I agree with it. But when you have an alleged offense that's kept caught on video and audio, that's different, isn't it?
It is, and in this particular case, you know, I can move forward. So Mr. Wilson cites a case in his motion, Williams, and I think that case is a little distinguishable. So in Williams, the state provided a video of the offense, but wasn't going to disclose the CI, and the defense was seeking in Williams the identity of the CI because they wanted to be able to challenge the video evidence that the state was utilizing.
But this is just pure that the CI can be identified.
What's that?
This is just because the CI can be identified in the offense.
In the video. But in the Williams case, it's distinguishable because I'm not seeking to introduce this video. I'm not seeking to introduce this evidence at all.
I understand that, but it's still evidence that but for that, the defense would be entitled to.
But
Whether,
for that.
but whether you're going to introduce it or whether you like it or.
But for the
I'm going to take it under advisement. I'm going to allow my law clerk to. If I deny the motion, it's not because I want to, it's because I don't have any other option, but.
I understand now.
If I could take just a moment, I understand maybe I should quit while I'm ahead, but I would just like to, well, it appears to be ahead anyway, you haven't ruled, but State
I would grant your motion if I was 100% sure that, and I don't, I think it was Mr. Ferrer about his friends in the appellate, I don't got no friends over there, and don't claim to have no friends over there, but I don't want to mess with them either.
I am 100% sure. If I could just point out a couple of things, Your Honor. First of all, Carter is 15 years old, and there's been a lot of law under the bridge since then on Rivera. And second of all, if you will look at Carter, there are two exceptions that Rivera carves out. One, the state cites, which is if we have a specific defense that we are seeking for. The other is in Williams, and I chose Williams intentionally out of a plethora of law because it does a fantastic job of outlining the fact there is a due process right, and that I believe the court is inherently hitting on, that doesn't require that we allege a specific defense. And Williams hammers on that over and over again and gives example after example. And the state's position that we don't intend to introduce the video makes it worse, because quite honestly, what they're asking you to do, we're moving from due process to trust me.
Well, okay, I understand the argument. If I was law enforcement, if I didn't want to use a CI, I wouldn't tape more audio on, but that's just if I didn't want to burn a CI.
I just, based off of that argument, Judge, so I passed forward State v. Carter. That deals with the first prong of the revival exception. Mr. Wilson's now, I guess, claiming that he's arguing the due process, the second prong.
I always have been.
I want to add, I don't have a copy of it, but the site is 24 Southern 3rd 715.
Do that again.
24 Southern 3rd 715. That's State v. LeBron. And
what was the last part? What was the page number?
715.
Okay.
LeBron. And in that case, it still says that even under the second exception to revival, the due process argument, that the defendant needs to initially meet the burden of showing that disclosure of the confidential informant's identity is necessary to a specific defense, and then the court needs to hold it.
I understand that. Listen, but I don't know that that's the issue. It's not just the CI, it's the videotape
That's
of
exactly,
the
Your
alleged
Honor.
events.
Yes, Your
Just because the CI is in there, that doesn't make it. I mean, I understand if they were just asking for the it just happens that the video that the law enforcement taped the CI with the offense.
Yes.
And it appears to me if they didn't want to do that, they shouldn't have used an audio or a video.
I agree with you, but disclosure of the video is automatically disclosing the identity of the CI.
They shouldn't have done it.
They created the problem.
They created the problem. And it seems to be that, and I'm going to take it under advisement, and that might be, and I understand I understand everybody's argument, but
yeah, this is truly not about the CI. I want the video because there are a plethora of things that can occur while he's alone in that car, allegedly alone in that car, that I have an opportunity to look at to make sure that it meets the legal standard.
I agree with you. So I'm going to take it under advisement. We're still in the discovery phase. Is that
we are? I think we still have depositions that are at least scheduled.
All right, let's just set it for the September 9th at 1:30. Okay.
Thank you.
All right. That's it for tonight, guys. I didn't have a lot. I apologize. I did not have a lot to share tonight. I kind of let it play a lot. I didn't really pause and talk. Probably should have. I did the little experiment where I was showing my face. I was showing my beautiful face. And yeah. That's all I got. I hope you guys have a great weekend. Don't do anything dumb. I will cover you if you do. But I will see you Sunday night. I won't see you tomorrow. So I'll see you Sunday night. That's it. I'm just going to end it. Have a great night. Have a great weekend. Until next time. Bye.
we essentially handled Mr. Upton because he was not here.